I've talked about sexual assault in the past, and sometimes it's confused with sexual harassment, and I just want to talk about these issues and explain how all this works. Now, I've been doing sexual harassment, sort of a side area of mine, for probably about 17 years, 16, 17 years. And so been doing this a fair amount. It's definitely a smaller side of my practice, but I've seen enough to know something about it. So I want to share some of this information with you. And so, first of all, what is sexual harassment? Well, sexual harassment is usually what you see in the workplace. That's how I see sexual harassment cases, and that's where a sexual harassment case will show up, is usually in the workplace. If you maybe it's not in the workplace, maybe you're sexually assaulted somewhere, and you think it's sexual harassment. Well, that's probably sexual assault. So sexual harassment, as we think about it, usually happens in the workplace. And for a sexual harassment case, there are remedies that are available to someone who's a victim of sexual harassment. So exactly what is sexual harassment? Is it someone rubbing your shoulder? Is it someone saying, hey, you look nice today? Is it someone asking you out on a date? Is it someone who's going beyond that and asking for sexual favors? So what is sexual harassment? And I've been involved in cases maybe that weren't quite sexual harassment, and learned the hard way that when we bring a sexual harassment case, it needs to be clearly and plainly sexual harassment. I myself don't want to get involved in cases where it's a gray area, where maybe a coworker is rubbing your shoulders, trying to give you a massage, unsolicited. Hey, how about a massage? That's probably in the gray area, is what I would say. And it's probably not a case that I would get involved with, because the intentions may have been innocent, and maybe there's no plan to try to seduce you or anything like that. And those are harder cases, and that's not a case that I would bring. And so what I'm talking about really are clear examples of sexual harassment. And in order for it to be sexual harassment, it has to be what they call sufficiently extreme. In other words, if someone came and started groping you, that's sexual harassment, clearly. Especially the private body parts. If they came and squeezed your belly and say, hey, you're putting on some weight, that's not sexual harassment. But if they grab your butt, if they grab other parts of your area that are really off limits, then that would be considered sexual harassment. So those are more clear violations. If you're being propositioned and saying, hey, how about we go hook up together, and maybe we can make it worth your while, and you can get promotion, we can raise your pay, things like that. That's called quid pro quo, meaning that the supervisor or the coworker is looking for something from you so that they can get what they want usually in the form of sexual gratification. That's quid pro quo sexual harassment. And the best cases for quid pro quo really are against supervisors who have the ability to raise your pay and give you a promotion and give you different perks and things like that. They also can have the ability to make your life miserable. And so it could come in the form of, if you don't go along with what I'm saying, we're going to write you up, you're not going to be enjoying things here, you're going to get a pay cut, we're going to cut your benefits, we're going to cut your job duties, we're going to demote you. It could happen that way as well. And sexual harassment could also be a bunch of different little things that happen in the office. And so, it could be, one day it could be, hey, you're looking good. The next day it could be, they brush against you too close. The next day it could be sending you a suggestive email. The next day it could be say, hey, let's get together after work. The next day it could be something else, so on and so forth. And when you add all of these things up, it really adds up to being sexual harassment. It's creating what they call a hostile work environment, where after a while you don't feel comfortable going to work. You're thinking, oh, what's Charlie going to do today? Is he going to hit on me again today? And when I say this, I don't mean to imply that it's only women that are being sexually harassed. We've done a number of cases for men that have been sexually harassed in the workplace as well. So it's not confined to any one particular gender. It could be pornography in the workplace. We're dealing with a case right now where there was, pervasive pornography spanning over a month and a half time, and our argument and our claim was that it created a hostile work environment. And certainly employers should know that when you provide an environment and you don't take care of an environment that allows women or even men to be objectified, then there could very well be a claim for sexual harassment. And so the first thing to do is identify it, and hopefully that will help you identify what it is. Now, what do you do if it's happened to you? Well, I think you should first look at if it's the employment context or if it's at work. Look in your employee handbook. What does it say if you've been sexually harassed? Who do you complain to? Follow the instructions in your employee handbook if you have one. If you don't have an employee handbook, or if your employee handbook is unclear on this, or maybe your company just doesn't have a policy, then you should probably talk to your supervisor about it. Now, if your supervisor is the harasser, then you should be telling the person that you're not comfortable with what they're doing. I'm hoping that you're doing that. But in terms of making a formal complaint, it's probably best to do that to someone who is not the harasser, someone who's maybe the supervisor of the harasser. It could be human resources, it could be the department head, it could be a number of people above that person. And is there any restriction as to making a claim for sexual harassment? Well, one of the big restrictions that we look at is the actual number of employees at the company. And in federal law, there's a requirement that there be at least 15 people in that organization in order to bring a federal sexual harassment claim. And so if it's a tiny organization, then maybe you're not going to be able to make the claim under a federal sexual harassment rule. And so federal sexual harassment provides protections for employees that work for employers that have more than 15 people. And you want to complain, like I mentioned, to the supervisor, to the HR. And there are other things you can do, though. You can complain to the EEOC. You can complain to the Utah Labor Commission. And you should be doing that. And how long should you be doing that in? Well, no later than 300 days from the date that you were harassed. Hopefully much sooner. Hopefully no more than 180 days. There's different statute of limitations that apply. And you should check with an attorney to see which one is applicable to you. But generally, anyone looking at this will look at the date that you were last harassed. And so make sure you don't sleep on your rights. They might say, well, we'll take care of it, and then they don't. And then it continues to happen. And then some people find themselves fired after they complain about sexual harassment. And then you have a claim for retaliation. So my message is don't sleep on your rights. Understand and know what sexual harassment is so that when you see it, when it happens to you, you're making the complaint, you're doing something about it, and you are holding the company's feet to the fire, because sexual harassment is illegal and you do not need to work for an employer that allows sexual harassment to happen in the workplace.